Lindsay, and then I'm going to hand things over to her. So, as I mentioned already, Lindsay is a Tulane alumni. She is a partner at Phelps Dunbar and is an IP expert. Lindsay works with national and multinational businesses across the Gulf South, the United States, and Canada to protect their IP portfolios and resolve complex commercial issues that often need immediate action. She is well-versed in handling emergency proceedings, temporary restraining orders, and preliminary injunctions. Whether helping clients enforce their intellectual property rights or defend against infringement claims, her quick response can start the litigation process off on the right foot. Lindsay is heavily invested in both the big picture and fine details of each case. This approach helps her discover paths others may not think to take, such as moving to dismiss if a client is being sued in the wrong jurisdiction. She regularly navigates large-scale federal lawsuits in both state and federal courts, including at the appellate level on issues involving trade secrets, trademarks, patents, and copyrights, complex commercial contract and business disputes, and constitutional law, including the First Amendment. Thank you, Lindsay, so much for being here today, and the floor is yours.
Thank you very much, Jalen, and thank you all for joining us today. Hopefully, no one on this webinar ever needs litigation assistance, but if you do, we are available to help. This presentation is less focused on litigation and more focused on understanding some basics related to copyright, hopefully in a way that helps entrepreneurs and other business folks understand what kind of rights they might have, what kind of rights they might want to protect, and what kind of steps they might want to take to ensure that they're not violating someone else's rights. And I also just want to invite anyone, if you have a question at any time or want to pause on something, please just let us know. I'm happy to take questions as we go, or reserve them for the end. Either way is fine with me. So without further ado, we'll get started. Back in. Advance my slide. All right, might have to do it the old-fashioned way. There we go. Okay, so really what we're going to focus on today is a kind of a specific doctrine within copyright law, and that's the doctrine of fair use. And I'll go through some definitions in a moment and kind of orient us in what we're talking about. But as an initial matter, fair use is a defense to copyright infringement. So there are certain instances when you can actually use something that is the copyrighted material of someone else if you're using it in a way that the courts have defined as fair use. So it's not, it does not mean that the other person's copyright doesn't exist when you use something in a fair use capacity. It just means you're using it in a permissible way. And we'll get into a few more details on that in a moment. Okay, so just some basics. A copyright is, under the law, the right of an author, an artist, composer, or other creator to control the use of their original work and to prohibit others from using it, determine the terms on which it might be used. I'm sure many of you have heard of a license agreement. So if you have a copyright, let's say you've written a novel or something like that, you could license it to be turned into a movie. You could license an excerpt to be printed in a magazine, something like that. So you get to control how your work is published in the world and who gets to use it. Just a little note on the legal side of that. The idea of copyright is that if you create something original and it's not just an idea in your head, but you've actually created it in a medium, then your copyright arises automatically. And so you don't have to do anything. You have a protected work. What's tricky about that, though, is if you want to enforce your copyright, let's say, again, the novel example, you wrote a novel and you want to prevent others from using it in ways you don't want them to use it. If you've not registered it with the US Copyright Office and someone else takes a copy of your work and prints it somewhere else without your permission, you won't be able to bring a copyright infringement claim until you have that federal registration from the US Copyright Office. So copyright can be a really complicated doctrine. It goes back centuries, but as a practical matter, if there is something that you've created that you wanted to protect, the best practice is going to be to register it with the US Copyright Office so that you'll have the full protection and ability to take action if somebody is infringing on that copyright. A bit more on what can be copyrighted, as I've kind of used some of this language: original work of authorship that can be fixed in any tangible medium of expression, such as written on paper, encoded on a disc, tape, recorded on film, a painting, a photograph, etc. And as a doctrine, what does copyright protect? It protects the form in which the ideas are expressed. It does not protect the ideas or the facts themselves. So what does that mean? That means if I have a great idea for a movie about, a team of jewel thieves, and it's very exciting, and I've written it up, I don't have a monopoly on the idea of an interesting story about a team of jewel thieves. What I can copyright is my expression of my story. So the exact things that happen in my story, the characters I develop, the plot points. I don't get to just prevent others from trying to write in that overall space, but I can protect what I've actually written and how I've expressed it. Okay, so here's just copyright is very large. It encompasses a lot. There are lots of different things that it can apply to, and some may be more obvious than others. I won't list every single thing on this slide, but you've got your more conventional things you would think of: writing, works of art, whether that's painting or something three-dimensional like a sculpture. You can also copyright source code, depending on how novel it is and how you've expressed it. And we'll get to some cases that talk about that a little bit later. You can copyright not only the music you may write, like on a sheet music. You can also receive a separate copyright for any recording of that music that you make. And then there are other rights that arise for live performances of the same music. So it's a complicated, overlapping area of the law that covers a lot of different things. A couple others just to point out on here: architectural works. You do see copyright infringement cases sometimes where someone has designed a specific house, or maybe has been engaged by, let's say, a planned community development to design homes in one particular area. And then somebody developing a similar kind of community in another area might try to use those architectural plans without permission. If that work is registered with the Copyright Office, that can be copyright infringement, because something like that can be protected. And again, you can kind of look through the list. A few notable things that can't be copyrighted. Generally, high fashion concepts can't be subject to copyright. Even though that's obviously a creative endeavor. So there are some things it doesn't touch, but there are a lot that fall within the umbrella of what can be copyrighted. And I guess one final note is that it doesn't have to be fiction. Nonfiction can be subject to copyright. Collections of facts, such as in databases, which is listed here. Your copyright protection would be in how you assemble the data, how you keep it, and your unique system of doing that, rather than, again, you would not have a monopoly on, let's say you made a list of, US presidents or something. That's a fact in the public domain, so you couldn't have a monopoly on such a list. But if you organized it in a database in a way that had a specific creative expression, you could use those facts within your copyrighted work. Okay, so as I mentioned at the outset, fair use is actually a defense to copyright infringement. So, and I guess I'll also just give a quick definition of copyright infringement itself. That's when someone uses at least a portion or perhaps all of a work that has a copyright attached to it without the permission of the copyright holder. And fair use is a defense to copyright infringement. And it is the right to use a copyrighted work under certain conditions without the permission of the copyright owner. So again, it does not mean that the copyright doesn't exist, but it means that you have a right to use it anyway. Over time, a test has been developed by courts who've considered this question as to how to determine whether something is fair use. And if you were, defending a lawsuit where you said your use of something was fair use, it would be your burden to prove that you use the work for the purposes that fair use applies to. Some common ones are up there on the screen: criticism, comment, news reporting, teaching. Another one not listed, but that's common, is parody. Like if you've created a parody song or a sketch or something like that. So the factors that a court considers are up here as well. And I'll explain what they mean as I go. So the first is the purpose and character of the use, including whether the use is of a commercial nature or is for nonprofit educational purposes. This is sometimes called, also referred to as the transformative factor. So the court will look at, let's say you took a piece of someone's work that was copyrighted and you turned it into something unique and different. That would be a factor that weighed in favor of your fair use, because you're changing the context in which the copyrighted material is expected to be found, and you are in turn creating something from that. A famous example that actually never really got resolved in the courts, you may remember the Shepard Fairey Obama poster from when he was running for president, and he used a copyrighted photograph to create this work of art that Shepard Fairey, the artist, argued was transformative. Interestingly, that case settled before the parties could, before a court weighed in on whether or not it thought it was fair use. But it is kind of a famous example of a new work of art emerging out of something that was copyrighted. So courts have sometimes considered this to be the most important factor, whether or not you're doing something unique enough that you should be permitted to use the copyrighted work. A couple of other examples, lots of people are familiar with the Harry Potter books. Someone other than J.K. Rowling published something called the Harry Potter Encyclopedia, which included a list of definitions of all the terms that had been made up from that series of books, things like Muggle, etc. And they were sued for copyright infringement and used the fair use defense. And the court determined that it was not fair use because although an encyclopedia is certainly different from a work of fiction that tells a story, it wasn't transformative enough, in the court's opinion, to show that the person that had put together the encyclopedia had really done something new. What they'd really done was compiled something created by someone else and just put it in a new format, rather than adding their own creative element to it. So those are just a few examples of how the courts analyze the first factor. The second is the nature of the copyrighted work. So you're always going to get more leeway to use facts, even if they are subject to copyright, than fiction. So again, if there's a news article, let's say the AP has published something newsworthy, and you are teaching a class on current events, you would have more leeway to reproduce part of that AP article and hand it out to your students, or if they had to pay for the copying, and we'll get into how the financial aspect might be important there. That's more likely to be permitted than if the same person teaching a class ran off copies of a book of fiction that they hadn't paid extra to make the copies for. They're just making copies for free for their students. So that's the second factor, the nature of the copyrighted work. Another factor that the court considers under that umbrella is whether or not the work has been published. And that's because the law really gives a lot of deference to the person who created a work as to how their work first enters the public sphere. So if you've been working on something a long time and you want to you've got a great magazine deal to publish an excerpt to drive excitement about your book, that should be your decision to enter into that agreement with a magazine. The magazine can't just decide to take an excerpt of it and publish it anyway. So whether or not the work has been published is a factor that the court considers, and if it has been published, you have a little bit stronger of a case on fair use, although it's certain that's not the only factor they'll consider. The next one is the amount and substantiality of the portion used in relation to the copyrighted work as a whole. That's somewhat self-explanatory, except you can, in some instances, use a very small amount of a copyrighted work, but if it is considered to be the, quote, heart of the work, then you may have used too much to qualify for fair use. So, an example would be if you only use, I don't know, 2 or 3 lines from a song, it might be proportionately a small amount of that song overall. But if it's a really well-known chorus, like say the Rolling Stones, I Can't Get No Satisfaction, if you took their chorus to that song, that would probably be considered the heart of that protected work, very recognizable. And even though you didn't take the whole song, that factor would weigh against your use. One thing to keep in mind, though, is that this factor is really not of much use if you're creating something that's a parody. You can generally, you have a lot more leeway if you're creating a parody. You may end up using a lot of the original work in order to signal to the mind of the viewer or the listener that you're making a commentary on whatever the original work is. And then finally, the effect of the use upon the potential market for or value of the copyrighted work. So really this means, what's the financial harm to the copyright holder? If you use a photo that photojournalist has used and licenses to various newspapers, magazines, etc., and they're making money regularly off the photograph, if you pull it off the internet and stick it on something that you're promoting, that's probably going to catch the attention of the photographer, because ordinarily you would need a license and you would have to pay for that use. If the court is looking at it and the person who holds the copyright can't really establish any financial harm, well, that will weigh in favor of fair use. And there was an example a few years ago from the musical Jersey Boys, which was subsequently turned into a movie. But when it was on the stage, there was a point in time when they would show a real clip from the Ed Sullivan Show, featuring the musicians, the real musicians behind the story of Jersey Boys. And CBS or whoever held the rights to the Ed Sullivan Show sued, saying, you got to pay us a license. And the court ultimately determined that was a fair use, in part because there was no financial harm. The clip was used to orient the viewer of the musical to the time period that we were in, and used as sort of a cultural touchstone, and not used to specifically profit. Obviously, the bulk of the work of the Jersey Boys musical was to come see the musical itself, not to come see this one small clip of Ed Sullivan from within. So that's the final factor that courts consider with fair use. So again, here's just some common examples of fair use. Sort of touched on this before. Criticism, if you're writing a piece that is discussing a recently published book or a movie or something like that. Comment, similar, except that would be more of your opinion than news reporting. News reporting is the next one. Of course, news reporting is going to have to include some information that the publication doesn't itself own, but so the doctrine recognizes that space needs to be made for journalists to be able to report on things that are happening. Teaching is an interest. Teaching, scholarship, and research, they all kind of go together. That's an interesting one. You can, if you are teaching or at a university researching or doing some kind of scholarship, you will get more leeway in using something that is copyrighted than someone who is not using it for educational purposes. and might be trying to profit off whatever it is that they're using. But it's not an unlimited right to use copyrighted materials. In my example earlier, usually if you're giving handouts to your students, like often if they are, at least when I was in college, which was a long time ago, we used to receive these packages in certain classes that were a compilation of various pieces of criticism or excerpts from different types of literature. I was an English major, so that's where I'm coming from. But we would have to buy them from the university bookstore because the university was paying a license for each piece that was in this compilation document. So if the university was to instead try to just run off copies and hand them out to all the students, that would probably go beyond the bounds of the educational fair use example. And so there are some limitations to the education exception. Okay, and this is just kind of a brief history of fair use. We don't have to, it's not a test, so we don't have to study this, but just so y'all know, it's a doctrine that goes way back. You can see the first case listed here goes all the way back to 1841. So copyright's a doctrine that's been around a really long time, and fair use has been around almost as long as copyright. Just in terms of kind of seminal acts of Congress, the Copyright Act of 1976 really codified a lot of what I've been discussing here in terms of what constitutes a copyright, what constitutes infringement, what are some of the exceptions like fair use, and you can see the quote all the way on the right under the purple is similar to that test that I just went through. A lot of this is kind of a summation of what we've been through. Fair use is a privilege for certain forms of copying, and again, it is a defense to copyright infringement, not a way to rebut the fact that someone has a copyright. Okay. So there's been some movement on fair use. You can see a lot of these cases are several decades old, but some of them are more recent, and I'll talk about even more recent things in a moment. But some of these cases just help kind of orient what the limits of the doctrine are. So the Williams and Wilkins case that you see up there at the top, that was a case involving the National Health Institute trying to use medical articles for research. And it was really the case that established that there is an education exception for copyright infringement under the fair use doctrine. So the court determined that the way that they were using the medical articles for research in this instance was fair use, and that there should be an opportunity for copyrighted works to be used in education and research without necessarily having to pay the copyright holder. Another one that has interesting implications as technology continues to develop, Sony Corp of America v. Universal City Studios, Inc., all the way back in 1984. This case was about Betamax, which actually, predates VCRs and certainly predates all of our modern streaming options. The issue there was that Sony thought that when consumers had the ability to record television and watch it whenever they wanted, that would be a form of copyright infringement because they were no longer able to control how their broadcasts were going. The Supreme Court disagreed with that, and they called it time shifting for personal use. So now pretty much everything we have is time shifting for personal use because you can stream anything at any time. But at one time, it was a question of whether the creator or the broadcast companies, the big media companies, should have the ultimate right to control when and how things were broadcast. So that's had that continues to have effects for the technology industry. It meant that even if your technology could possibly be used in an infringing way, and to use this example, if somebody taped a movie off TV on their Betamax back in 1984, they could have their friends over and show them that movie instead of renting it from the video store. technically that's costing Sony money. Technically, those people could be infringing on Sony's copyright in their broadcast. But the tech company that made the Betamax that allowed that to happen was not responsible should someone inappropriately use their technology. And moving on down. So the Lotus Development Corps case, that also has kind of modern implications because it was about spreadsheet software. And the two parties there had developed competing types of software. And the defendant had used the command order that the plaintiff had used and first developed in order to do similar features with their 1996 level spreadsheets. And the plaintiff, Lotus Development, said that by using the same command order, they were violating their copyright in that code. And again, the court determined that it was fair use and that elements of software development that are functional are not part of the source code. That is, they're not part of the copyrighted writable source code. So anything functional is kind of outside the scope of a copyright. So again, that case continues to have lasting effects because we're constantly developing new forms of technology, writing new kinds of codes. And so anytime something is deemed functional, it won't necessarily be able to be protected by copyright and others could use it. The Google v. Oracle America case, that's a really recent one, well, relatively recent one. I will discuss that in a second, so I'm gonna skip that for just a sec. And to go through the others, they're more in the media space. The CBS case, it was a question, so they're about derivative works, which are when you create a new work based on an old work. So CBS had a TV adaptation of the 1930 movie The Cane Mutiny, which was in turn adapted from a novel. And so CBS, Lowe's, the movie theater company, had the copyright license from the writer of the book to create this movie. And then CBS didn't bother to get a license. It went out and just made this movie miniseries TV show based on the same book and based on the movie without permission and claimed that it was fair use. And the court disagreed with CBS's right to do that there. It said you need a license. So even though they were creating something new, and even though something had already been adapted once from the novel, they still needed to get a license to do that. The Campbell v. Acuff Rose Music Inc. case, I don't know if anyone on this webinar is old enough to remember this, but this is a Two Live Crew case that Two Live Crew was a rap group in the 90s, received a lot of attention nationally, and they sampled the Roy Orbison song Pretty Woman, famously also used in the movie of the same name. But they created a new version of the song. They used the bass line and they used some of the musical cues in throughout the song, but the lyrics were all different and the purpose and sort of intent of the lyrics were different. And so they were sued for violating the Orbison copyright. This was a surprise at the time. The Supreme Court sided with Two Live Crew and said that this was a transformative use. The song is completely different than the original song. It in some ways parodies the original song. And because of the novelty that Two Live Crew brought to the new song, they had not, they were entitled to the fair use defense. And another important part of that case was that obviously in that instance, Two Live Crew wants to make money from its music. So there was a huge financial component, and the music company was saying, they've made all this money off of someone else's copyright. That's usually a pretty important factor. If you're profiting quite a bit off someone else's copyright, that weighs against the fair use defense. But in this case, the court said it didn't. The fact that they had a commercial intent, that they wanted to sell records, that didn't mean that they couldn't use that bass line and portions of the song, as long as they transformed it into a new kind of expression. So that's why you may hear, similar things in modern songs, sampling pieces, transforming them. In many instances, people get licenses anyway, just to be safe, but that was kind of another watershed case. And finally, this Harper and Row case, this is something I kind of alluded to earlier. This was about the memoirs of Gerald Ford after he was president. He entered into an exclusive deal with Time magazine to publish an excerpt of it. Before they published it, the Nation scooped it and published it. And the court determined that that was not fair use because, and a large part of that was because it hadn't been published. And so they said Ford had the right to decide how it would first enter the public sphere. And also, it was important that they had selected what was considered to be the heart of the memoir, the portion that would be most likely to engage people and drive people to buy the book. And therefore, they should have had to pay a license to Ford for that privilege. So, so that kind of shows the limits of fair use. Okay, and so now we're into some more modern stuff now against that backdrop. So there's a case making its way through the courts right now. It started in the Southern District of New York, which is where New York City is. It's now currently with the Second Circuit Court of Appeals, which is over New York among other states. And so the background of that is that the Internet Archive was sued over its controlled digital lending practice, which allows libraries to digitize physical books they have, and then allow users to check them out digitally. And so the question was whether by purchasing the physical copy and then creating a digital version, the libraries were committing copyright infringement, and separately whether they could use the fair use defense. And the Second Circuit held that it was not fair use, even though the libraries were restricting the digital access to the number of physical copies they had. So if they had one copy of a book, they would only allow one digital copy to be checked out, and so on and so forth. And so the argument was that they weren't actually depriving the publisher of the right to be paid for the book. They were just offering it in a new way for their users, in order to facilitate a different way for reading. But the Second Circuit disagreed. It determined that transforming something from a physical copy to a digital copy is not transformative, and that all the factors we've been going through actually favor the publishers, and that it didn't matter if the libraries were not making any money off of this. They're still potentially depriving the publishers of money that they could be receiving for the digital copies. So that case could go up to the Supreme Court. We'll see what the Second Circuit does, but it's something to watch in terms of if we're moving away from physical copies of things into digital copies, what are the limitations? Do you need to seek a license? It's something to keep in mind. Kind of good. My next slide is actually on this as well. So you can kind of see this is the fair use factors that the court went through. I kind of already went through this, but I'll just give a second if you want to take a look at the slide. One thing I didn't mention was that obviously when you digitize an entire book, you're using the entirety of that work. So that's one of the factors, and that weighed against fair use. Yeah, finally it could affect the market for publication of the books. Okay, and this is one of the most recent Supreme Court cases on fair use. Andy Warhol Foundation v. Goldsmith. So this is the center of this controversy is that image on the right, the quote orange prince, which was a work of art that Andy Warhol put together. The image on the left is the original photograph of Prince that was taken by a photographer, I think name is Lynn Goldsmith. And so, so the question was, was this use of this photograph fair use particularly did Warhol transform it into something new? So at the outset, what's interesting is that they had actually licensed this photo, as you can see, for $10,000 to use on a magazine cover. And then later, Andy Warhol used that image to create this orange, well, he made an entire series, but the one at issue in this case was the orange prints. The photographer didn't know about it. This was happening, Warhol created in the 80s. He is no longer alive, but his foundation still controls his works. And so when the photographer found out in 2016 that her image had been used in this way, she sued for copyright infringement. And the Andy Warhol Foundation argued that there was no infringement because it was a fair use. And this was a very closely watched case among copyright attorneys such as myself. The court held that it was not fair use, but first and foremost because of the commercial nature of the work. So obviously, they were profiting off of the work of the photographer without her permission. The court also considered whether it was a new expression, a transformative expression of the original photograph, but it ultimately determined that although they look different, they were used for the same purpose. They were both used in print media, basically, on magazine covers. And so although the images were not identical, their purposes were too similar, and Goldsmith had been collecting licenses for her photographs for use on magazine covers or in magazines. So that factor also weighed against the Warhol Foundation. So the court really focused on the commercial use here. You've seen that last bullet point. It also specifically mentioned that different uses, like educational purposes, might have led to a different outcome in this case. If they hadn't been profiting from it, and if they hadn't been profiting in the exact same sphere that the photographer operates in, then they might have had a stronger fair use defense. But because they were essentially depriving her of licenses that she might otherwise have collected in the same industry she works in, that was very important to the court's analysis. So another really big topic in copyright now is generative AI, and I will just say right up front, nothing has been settled on that. The Copyright Office continues to try to stay abreast of technological developments. They put out guidelines. If you're ever curious, you can go to the copyright.gov and look through some of their guidelines. But these are questions that are going to be decided by courts in the coming years. And just as somebody who works in IP, it is rare that the court system can move as quickly as technology. So often we will have years and years of use within a specific technology before we get any kind of real clarity from the courts on whether or not they believe something is violative of copyrights, or whether it can fall into a defense like fair use. So it probably won't be settled immediately, but it will continue to be an issue to watch, especially if you're using generative AI in your business at all. So if you're not familiar, what happens with generative AI a lot of the time is that they are taught, they have to learn, and they are taught information so that when you put in a question or a task or a request, they can respond in a way that sort of makes sense. So they're fed, so much more information than I could possibly summarize in order to produce outcomes that are useful to the users. And this includes texts and images, many of which are subject to copyright. So but importantly, so there's that component of it. What you're putting into the AI to teach it. And if you are putting copyrighted materials into the AI to teach it, are you committing copyright infringement? We don't really have a very clear answer on that yet. The second question is, what about the work that the AI generates? If you ask the AI to generate, let's say, a painting in the style of Pablo Picasso, and it does so, how close does it have to be to a Picasso before you're potentially infringing on, the Picasso Foundation's rights in his works? These are, again, just questions that have not been definitively answered, but will be coming up through the court system. So let's say you put something in and it generates it out. Can you claim, and let's say it's totally unique, you're not getting too close to Picasso, you've like created a portrait of yourself or something using AI generated work. Who holds the copyright ownership for that? Generally, when you create a work, you are the owner of the copyright. But what if you're assisted by AI? That question also remains somewhat unanswered, although I believe the latest guidance, and I'd have to double check on this, I think the latest guidance is you have to disclose AI assistance, and that things like completely created by AI would, you, the human, are not the creator of that. But I don't quote me on that, because that's kind of changed a little bit over the last year or so. So then there's also the question, are AI companies liable for copyright infringement due to their use of training data? That goes back to some of those cases we were reading. You know, the Betamax case could ultimately become important here. The companies themselves that have created the technology may be able to use that precedent to say, hey, we just create the technology. We don't necessarily deal with what happens on the other end. And then, you know, can you argue fair use? If you're teaching an AI model, can it fit into education? Can it fit into something transformative? These are all really kind of hot button topics in copyright law right now. But there is a big case that is going to go, you know, very well could go up to the Supreme Court. The New York Times sued OpenAI, which is a Microsoft product, and it alleged that the AI's language models were being trained on, as you can see, millions of New York Times articles without permission, and that the outputs it was creating were directly harming the New York Times business in the realm of journalism. OpenAI has responded that its data sets are fair use, and that they're using it as kind of a search engine uses content. So this is an open question, and this is a case that's ongoing. It will be interesting to see where it goes. And another thing that is kind of an interesting component of all this is there are some judges and courts that are really well versed in technology, but many are not. And so and this has always been the case with intellectual property. You sometimes are having courts decide this that don't have a lot of experience in this subject matter. So that can be, you know, advantage or a disadvantage depending on what side of it you'd like to argue. But it contributes maybe to the lack of clarity that we've got so far, because judges are people too, and many of them are trying to understand and fully learn what this means and how it can interact with the existing doctrine. Okay, on to something a little more fun. Fair use in social media. Can you get sued for using a meme? Probably not, and the reason is fair use. So as we've been discussing this whole time, when you transform something, when you create something new based on something that already exists, then you've got the first step toward making a fair use defense. And often, you know, memes are used humorously to kind of comment on current events, or you know, make a joke about a public figure, something like that. These are also the types of uses that often fit well into the fair use defense. And so far, the law is that, you know, as long as you're not interfering with the original copyright, you know, that you can share a meme even if you didn't take the photograph, etc. And you can make your own meme by transforming, putting your own caption on it, whatever, sharing it to social media, because, you know, most people are not profiting off the sharing of memes. If you're an influencer, that may be a different question. But if you are just an everyday person using social media, there's no harm to sharing a meme or putting a new caption on a meme. Where you get in trouble is if you try to make money off of a meme. So the little baby over there is known as Success Kid. You know, you may have seen many memes with him. the implication is usually something good has happened. And so a few years ago, a politician running for office in Iowa started using this image in his political campaign. And he was served with a cease and desist and ultimately a lawsuit by the mother of the kid pictured, because the kid was a minor. And he was required to stop using the photograph. And I believe he even had to pay some damages for doing it. Same thing, there was a fireworks company that used the same image. They were also served with a cease and desist and eventually a lawsuit. They also had to stop using it. So, there's some practical tips for how to avoid. I mean, you can always use public domain works, and then there's no, if something's in the public domain, you don't need to seek permission to use it. But the other key element is you don't want to be profiting off something that you didn't create or that is not your original work. And if there's a photograph involved that you didn't take or an image that was created that you didn't create, chances are that's someone else's copyrighted material. So you don't want to be using it to promote your business or otherwise try to make money off of it. A little bit more about social media. If you truly created your own viral meme, like if you were the mom of that kid and you were the first one who ever posted that with a funny caption, and your meme goes viral, you already have copyright protection. As I mentioned, it arises from the moment of creation. But you still would have to file it with the U.S. Copyright Office if you want the full span of protections that are available to ensure that nobody has infringed your copyright. But posting something online satisfies the fixation element just to create a copyright because it can be seen by the public. And as you can see, nearly any modicum of creativity satisfies the originality requirement, but again, it has to be independently created, not that you put a new caption on a meme that already exists. And I will also add that these elements I'm going through about memes, they're basically true for anything you might create. The protection arises automatically from fixation and originality, and that the modicum of creativity can be low so long as you're not deriving it from somebody else's work. And again, I've mentioned this many times, but fair use protection is not the same as copyright protection. You can fall into the fair use defense from making a meme from someone else's work, like if you transformed it, but you would not necessarily be able to receive your own copyright protection on a meme if it was not your own original work. And last, I've already mentioned this, you can always register something you've completely originally created with the Copyright Office. Okay, this is the case that I said I was going to come back to. This is a little bit more on source code, and we are not too far from the end, so don't worry about that. So this was another really big case that a lot of copyright lawyers were watching. Oracle owned a copyright for a specific kind of JavaScript, and Google had copied part of the program. I believe it was in some Android devices. And Oracle sued Google and said the code was copyrightable and that the use by Google was not fair use. And this case went, generally, like if a case is in litigation, it starts at the district court. If someone disagrees with the outcome, they appeal it to the Court of Appeals. Then they can try to appeal to the Supreme Court. The Supreme Court doesn't have to take the case. This case went from the district court up to the Court of Appeal, back to the district court, back to the Court of Appeal. It went back and forth. It was a lot of really complicated questions, kind of a first impression for the court to consider. And finally, after years of litigation, finally ended up at the Supreme Court. And so the Supreme Court found in Google's favor and said that the fair use doctrine protected their use of the Java programming that Oracle had done. And so, again, this was similar to that case I mentioned all the way back with the data spreadsheets with those simple commands. That's essentially what the court found here, that the pre-written code that was using simple commands was so general that it was not a copyrightable idea. And so the application of fair use, sorry, I just stumbled on my words. And so anyway, that section on its own was not necessarily copyrightable, and therefore it was a permissible use for Google to rely on portions of the code. Okay, and so this is kind of like the nitty gritty on what the court did here. The portions that they were using, again, were simple, but where it led in the source code, the court determined was transformative. It had a different purpose than how Oracle had used it, and was kind of new and different. And so that factor weighed in Google's favor. And again, although you can see Google copied approximately 11,500 lines of code, that was only 0.4% of the entire Java code. So the amount and substantiality portion or factor also weighed in Google's favor. And then this last one is interesting. The court determined that the effect would not harm Oracle's market for Java because it targeted a different market segment and did not replace the original product. So essentially, there's room for both competitors here, and Google's use was not encroaching on Oracle's market share. All right, and that is the last case that I had to discuss and sort of the last topic. So with that, if there are any questions, I'm happy to take them.
So I did see a question in the chat about copyleft and how does open source licensing influence copyrights?
Let me see. I'm just trying to actually look at the question itself. 1 second. Okay, I'm not sure if I totally understand the question. So if something is open source, then it's being shared with, it's permissible to be used by anybody. And it wouldn't really, you wouldn't have to subject it to this copyright analysis. I don't personally know what copyleft is, but.
It actually speaks of derivative sources, Lindsay. So what happens is there are different open source licenses that require you to actually put in, attribution to the originator of the code.
Okay, I'm sorry. Can you just repeat that last part again? I heard most of it, but I didn't hear absolutely everything.
Okay, so hopefully you can hear me. A lot of open source have different licenses that open source gets attributed to. So depending on the license, if you do a derivative code, there are some licenses that say that you have to actually give attribution to the originators of the code.
And so I'm sorry. And the question is just how does that work, or?
Yeah, and so I had heard the term copyleft to apply to that particular type of copyright.
I see. Well, I mean, I think if the open source material that you're referring to, if it is just asking for attribution, then that may be enough for that person who has created that copyrighted material. I would frankly just have to research copyleft a little bit more to understand how it works. But if something is offered for open source where the creator is saying you don't need a license to use this is for anyone to use, then you can use it without fear of a copyright infringement case. If they're asking for something in return, an attribution, a licensing fee, etc., then that's a different situation where you would want to make sure that you are following the parameters that they've set forth for use. But that's interesting, and I would love to learn more about that. I haven't had that come up before, so I'll be interested to research that some.
Yeah, it's interesting if you're in the software business. And the idea of using AI to generate different artifacts, it's actually being used in codes today. So that
Mm,
you actually train, like Microsoft trains some of their code development tools to generate code on your behalf, code
yeah,
completion. And they were actually worried about getting sued because of all of the samples that they have to feed into the training set may actually
right.
wind up mimicking something that gets automatically generated on your behalf.
Right. Yeah, that is a really interesting development that is going to be, I think we're going to see play out in lawsuits, and maybe even some of the tech companies will try to enter agreements with each other to protect themselves. I don't know where it will head from a business standpoint, but it is just not a question that has been resolved in any kind of definitive way by the courts, and that's only one way to resolve disputes among private parties. So if for instance, Microsoft or another tech company is generating something and, another tech company says your generative AI code is violating my copyright infringement, they could work out a licensing agreement among themselves without ever presenting the question to the court. So I think that you will see some business solutions and you will also see some court cases out of it. And probably the mix of the two will start to develop to give a sense of how this will be treated going forward. It may become commonplace just to enter agreements with one another instead of taking it to the courts every time. But that remains to be seen.
Yeah, I can see where some of the businesses will actually indemnify. They say, if we generate code on your behalf, we'll accept the risk.
Yeah, exactly. That may be where we're headed. It will depend on, I think, how they assess the way to best minimize their risk, and perhaps that's it. But it seems as if the major players are still figuring that out themselves, as the law kind of lags a little bit behind.
So Lindsay, we did have one more question in the chat, and I do want to be mindful of time.
Sure.
Copyright protection expire?
It does expire. It is, it's like life of the author plus, I'm gonna misquote the life of the author plus decades and decades. So you are able to maintain a copyright well beyond the life of the person who created it. If like the Andy Warhol Foundation, for instance, can maintain his rights. However, at some point, you cannot renew a copyright further and it enters the public domain. And that means that others can use it without copyright licenses or attribution. A really famous American novel that entered the public domain a couple of years ago was The Great Gatsby. There does, and I believe one of the early Mickey Mouse drawings also just entered the public domain, which is interesting because Disney is very, very protective of its intellectual property. But that's the part of the point of copyright law, is that you don't get to create something and hoard it forever and prevent others from ever being in a similar space. It's supposed to be limited in order to foster creativity and development. So the answer is yes, they do expire. I'm sorry, I don't have the exact number of years at the top of my brain, but it is a lengthy time period. And there are also some complications based on when you published it, et cetera. So it can be a complicated question, but eventually they all do expire.
Okay, excellent. Thank you so much. If you wouldn't mind going over to that very last slide you have.
Oh, sure. Apologies there. There you go.
Okay, so thank you all so much for joining us this morning to discuss copyright crossroads and balancing creativity with fair use. I hope some of your takeaways are that copyright is the right of an author, artist, creator, etc., to control the use of their original work. For example, licensing a book to a movie studio. We learned a lot about what could be copyrighted, including poetry, music, sculptures, but we also learned that high fashion concepts cannot be copyrighted. We saw an example of Betamax, which I haven't heard the word Betamax in some time, but Betamax was sued for recording TV, and the court ruled that it was time shifting for personal use, which I'm very thankful for on a daily basis. So we hope you will join us in the future for some of our events. On November 19th, we have our open season pitch competition at Oak and Ale. On November 20th, we'll be right back here for another webinar on bootstrapping and grant writing. And then on December 4th, we have another webinar to discuss free and low-cost marketing strategies. So thank you all for joining us, and have a good rest of your Wednesday.
Thank you.